there are two applications. One is the notice of motion for expedited appeal, and the other one is the notice of appeal for the injunction itself. The Court of Appeal must first decide if they will even hear us on our disagreement with the Chief Justice that he should have granted the injunction. The Chief Justice granted the injunction, remember, and we want the Court of Appeal to hear the merits of that issue only and hopefully reverse it in our favor. However, the Court of Appeal has to decide first and foremost whether or not they can even hear it based on the rules of procedure under the Court of Appeal. The other side has put forward the argument that you cannot, under any circumstances, hear an appeal within 21 days after a judgment has been passed. Our position is that since the rules are silent on when you can bring an expedited appeal, that the Court of Appeal should use its inherent jurisdiction to grant an expedited appeal and hear the matter today. That was our argument, but the other side will get a chance to present this afternoon, and then the Court of Appeal will first decide whether or not they will even hear our appeal on the injunction.
Because of how long this morning went in terms of that application, is there some concern that the government will not be able to meet the deadline for Wednesday?
Well, there has always been that concern that the government would meet the deadline for Wednesday, but you cannot rush court time. It takes how it takes. I mean, it takes as long as it will take. We believe that it's been going very efficiently so far, and it will continue to do so. And I don't think that the Court of Appeal will be too minded to go as long as they can, given the circumstances of the case. So I wouldn't be surprised if we go for a certain period of time, and if necessary, go beyond that, and late if we have to. I don't doubt that the Court of Appeal would want to do that and finish. I hope that whenever they decide, they can decide very quickly so we can know what, if any, steps we need to take.
Are you at liberty to speak on the content matter that Senior Counsel Schuman is attempting to put before the court?
Liberty in what way?
Speak on that.
You speak on it in what way? No. According to him, Ms. Tamai was in contempt of court when she continued the preparations for the referendum on April 10th. Ms. Tamai sent an email, said based on legal advice, which she got from me personally. She called me on the phone and I gave her the advice that the Chief Justice had only said that the referendum could not be held on April 10th. The Chief Justice clearly also said that there are 3 Court of Appeal judges resident in the jurisdiction, and that clearly he was anticipating a quick appeal. At no time did the Chief Justice say that preparations for the referendum should stop. And in light of the fact that it's very likely, possible, that the Court of Appeal could, if it so decides, reverse the Chief Justice's decision today, then there would be a different comment had the people stopped their preparations only to have a referendum April 10th and not be ready. So it was my advice for her to be ready in the event that the referendum will still be held on April 10th. And that was clearly spelled out in her letter to her co-workers, and that was clearly my advice. I think it's a non-starter, to be honest with you. I think it's more for sensationalism than anything else. But I don't think that, and they've already given indication that they may abandon that argument. So I don't, it's neither here nor there as far as I'm concerned. She was not in contempt, clearly not in contempt. I would not have advised her to be in contempt.
Is government even contemplating not having this referendum on Wednesday? What happens if the appeals court says, okay, we'll reserve judgment until a month down the line?
Well, in that case, then we have to surely consider, we continue to consider the possibility that the referendum will not be held on April 10th. We know that if the Court of Appeal makes a decision today then refusing our application for an expedited hearing, we know that the CCJ doesn't close and they have no rules and restrictions as pertains expedited hearing. They could hear it tonight, midnight, 2 in the morning if they want to. So there is that option. But indeed, if the Court of Appeal refuses us, then I would say it would be fair to say that having the referendum on April 10th would be in serious jeopardy. Although not impossible, it would be an even steeper climb to have it on April 10th if the Court of Appeal rejects us today.
So what's the sense of urgency should it come down to the wire?
What do you mean, what's the sense of urgency?
To want to push it to April 10th, notwithstanding everything that has happened.
It is part of the case. A lot of preparation has been put into making sure this referendum happens April 10th. A lot of time has been taken away from public servants in order for them to prepare for this referendum. We have all the observers, most of them already in country. We have everything in place for April 10th. To push it back to another date, and we will if we have to, but to push this back another date would cause considerable expense and just overall, it would be troublesome to have it be on April 10th. If we have to, we have to, but it will be very uncomfortable and expensive to extend it some more time. So we're trying to preserve, save some money, save some harassment, and have it April 10th if we can.
Has there been any consideration given at the highest levels to say, you know what, let's just listen to what some of the people are saying and let's just postpone this 1 month, 2 months, 3 months down the line and try to get different things in place?
The UDP always listens to the people. That's why they're in government. I mean, you listen to the people. Our people are telling us that they are ready for a referendum on April 10th. The people have said, even those who may want to vote no, have said, I want my chance to vote. So what we're fighting for is for people to have their right to vote however they want to vote in the referendum. If it has to be pushed back, it has to be pushed back. But there are people who have traveled from, regular citizens of Belize who have traveled from abroad to be here for April 10th. The people have gone to considerable expense to be here, and so they want their opportunity to vote April 10th. And I think it would be irresponsible of the government to not fight for the date that it has set and it has made people expect would be the date that you would have the referendum. We have to fight for April 10th as hard as we can. If the court decides otherwise, then we just have to go in a different direction. But we have to make the people know that we consider the inconvenience that they have gone through in order to vote on April 10th, and we want to respect that and have that vote on April 10th.
So the other